22. What is law? In his Apology, Tertullian makes a significant comment about the Roman emperor. But why dwell longer on the reverence and sacred respect of Christians to the emperor, whom we cannot but look up to as called by our Lord to his office? So that, on valid grounds, I might say Caesar is more ours than yours, for our God has appointed him. Therefore, as having the propriety in him, I do more than you for his welfare, not merely because I ask it of him who can give it, or because I ask it as one who deserves to get it, but also because, in keeping the majesty of Caesar within due limits, and putting it under the Most High, and making it less than divine, I commend him the more to the favour of the deity, to whom I make him alone inferior. But I place him in subjection to one I regard as more glorious than himself. Never will I call the emperor God, and that either because it is not in me to be guilty of falsehood, or that I dare not turn him into ridicule, or that not even himself will desire to have that high name applied to him. If he is but a man, it is his interest as man to give God his higher place. Let him think it enough to bear the name of emperor. That too is a great name of God's giving. To call him God is to rob him of his title. If he is not a man, emperor he cannot be. In this important statement, Tertullian held, first, that Caesar belonged more to Christians than to non-believers, because he held office by the providence of the triune God. Whether as a blessing or as a judgment upon all men, the emperor ruled only by the permission of God. Our God has appointed him. For unbelievers, life being meaningless and purposeless, rulers are accidents of history. For the Christian, they are aspects of God's purpose and plan. Second, the persecuted Christians, said Tertullian, do more for the emperor's welfare than unbelievers. Besides being the salt of the earth, Christians pray for the welfare of their country. Even more, by refusing to recognize the emperor as a god, they keep his majesty within due limits. They place the emperor in their obedience, in subjection to God. Third, Tertullian said he would never call the emperor God. This marked his faithfulness to God and gave to the emperor his due place wherein alone he could be blessed. Tertullian also insisted on religious freedom. In Ad Scapulum, he wrote, 2. We are worshippers of one God, of whose existence and character nature teaches all men, at whose lightnings and thunder you tremble, whose benefits minister to your happiness. You think that others too are gods, the same we know to be devils. However, it is a fundamental human right, a privilege of nature, that every man should worship according to his own convictions. One man's religion neither harms nor helps another man. It is assuredly no part of religion to compel religion, to which free will and not force should lead us. The sacrificial victims even being required of a willing mind. You will render no real service to your gods by compelling us to sacrifice, for they can have no desire of compelling us to sacrifice. For they can have no desire of offerings from the unwilling, unless they are animated by a spirit of contention, which is a thing altogether undivine. Accordingly, the true God bestows his blessings alike on wicked men and on his own elect, upon which account he has appointed an eternal judgment. Then both thankful and unthankful will have to stand before his bar. Technically, Rome did not believe in religious persecution. However, because it believed in the control and regulation of all religions in terms of its fundamental law, the health or general welfare of the people, its policy meant the persecution of Christians. Religious persecution entered the church with Augustine, who adopted the public welfare policy. Rome's highest law as his policy against the Donatists. The Roman authorities cooperated. In 1906, T.P. Ellis in Welsh Tribal Law and Custom in the Middle Ages pointed out that crime is a modern phenomenon. A crime is an offence against the state. This means 4 things. First, there must be a state. Second, laws must come from the state. Third, crime is an offence against state law. Fourth, punishment is in accord with state law. Criminal law thus presupposes the state as the source of law, as sovereign. Prior to the development of statist law, wrongs done were not against the state but against persons or groups of persons bound together as a family or clan. Such wrongs were not crimes but torts, and action was taken by the aggrieved, not the state. If instituted in courts, it was not the state versus John Doe, the offender, but the injured party versus John Doe. The case was different in a theocratic society, as J. R. Reinhardt pointed out. In a theocratic community, on the other hand, the attitude toward crime and punishment was somewhat different. Here, as in other primitive societies, there were, to be sure, wrongs or offences of man against man which were matters of private adjustment, to be settled between the parties on the principle of retaliation or by the payment of damages. But such wrongs as murder, incest, adultery, and similar offences against the sacred laws of blood constituted an insult to the whole community and were punished by the whole group. The person guilty of such a wrong was impious and had to be cut off from his community by death or outlawry. But whereas a civil offence must be punished, the idea originally connected with the execution of a tribesman was, among the Hebrews, not exactly penal in our sense of the word. The object was not punish the offender, but to rid the community of an impious member. Indeed, the death or banishment of such a wrongdoer was a matter of religious duty, for if he were not cut off, the anger of the deity would rest on the whole kin. Hence, when a tribesman is executed for an impious offence, he dies on behalf of the community to restore normal relations between them and their God. In other words, in a theocratic society, some wrongs were regarded as offences against the deity, that is, as sins. Reinhardt's summary is a good one, despite its religious defects. Above all, in a theocratic society which is biblical, all offences are sins against God. Whoever else may be offended, whether the crime or offence be theft, murder, adultery, perjury, or anything else. To summarise, law can be, first, customary law based on clan requirements and involving torts. These are wrongs done by one person against another, in which the prosecution is the work of the aggrieved. Second, punishable offences can be crimes against the state's law, as against family, clan, or tribal law, and the state, having made the law, is the aggrieved and prosecuting party. In the United States, the victim's hurt is, according to more than a few judges, incidental to the state's concern. Third, because, for Christians, God is the source of all law, all offences are sins. Some sins are punishable by the civil authorities, but not all. Any reading of biblical law makes it clear that many offences are not punishable by any agency of man, because God reserves that power to himself. For men to believe that all offences are punishable by some human agency is for them to play God. Genesis chapter 3, verse 5. Thus, prior to Augustine, theologians like Tertullian asserted religious freedom. The sins of apostasy, heresy, and unbelief, among many others, are not punishable by man, but only by God. For the state to define offences and then to punish them means ultimately totalitarianism. If the state is the source of law, then it is the source of punishment for all transgressions, and no dissent is permissible. As a result, systematically humanistic societies become totalitarian and tyrannical. They move from punishing offences to punishing dissent. They move from the control of criminals to the bureaucratic regulation of all men and all institutions. The possibility of dissent and of violations of law is ostensibly obviated by controlling all in order to prevent offences by total regulation. Laws to effect the redistribution of wealth and resources then follow. Not the evildoer, but the law-abiding and the productive are controlled and, in effect, punished. For Tertullian, because the offence was against God, men could not intervene unless required to do so by God's law. But this is not all. Tertullian said of the emperor, "Caesar is more ours than yours, for our God has appointed him." The fundamental government and order come from God. He is the sole source of law, the determiner of good and evil. This reduces all Caesars to ephemeral objects because the government is upon Christ's shoulders, Isaiah chapter 9, verse 6, and he alone can prevail. It is God who is our refuge and strength, not Caesar. Psalm 46. Law is the expression of the will of the sovereign power, and nothing and no man can prevail against the sovereign. If man or the state is the sovereign, then the sovereign will prevails, and the sovereign, as the source of law, cannot be bound by any law. If, however, God is the true sovereign over all things are subject to him under his law word and shall be judged by him. The importance of the Last Judgment has receded in theology and life as biblical law has been neglected. In 1885, Dicey set forth the three meanings attached to the expression the rule of law. First, it means the absolute supremacy of regular law as opposed to the arbitrary power of the state. Second, the rule of law excludes the exemption of state officials from obedience to the law and subjects all classes equally to the law. Third, the rule of law means that the law of the Constitution is not the source, but the consequence of the freedom and rights of individuals. The creation in recent years of agencies given powers to make regulations not subject to legislative review and approval has seriously undermined the rule of law. The rule of law concept presupposes the ultimacy of God as sovereign over the nations and the source of law. The question, what is law, can be answered first by stating that the definition of law varies from one culture to another in terms of the religious faith of each society. There is a difference between Soviet law and biblical law, to cite two extremes. Since law is the will of the sovereign, what or who the sovereign is will determine what the nature of the law will be and how it can be defined. Second, apart from biblical faith, law sooner or later evaporates into nothing. In Buddhism, nothingness is ultimate, and it is thus a logical conclusion to hold that men and laws are nothing, and some Buddhists have affirmed this. Soviet law is the will of the dictatorship of the proletariat. It changes and is basically an irrelevant concept because it is subordinate to the plan of the Soviet elite rulers. Human laws are variables of human willing. Thus, in the United States in 1928, it was a crime to have in one's possession a bottle of whiskey, but legal to have a bar of gold. Then, in a few short years later, the matter was reversed. The whiskey became legal and the gold illegal. In either case, the quote-unquote law was an arbitrary act of the state, not an expression of fundamental morality, as with the Ten Commandments. Beginning with Justice Holmes and on to the present, American justices have held that religion and morality have nothing to do with law, which is the will of the state. This was a position also of National Socialism, a faith much despised by speech in the United States while pursued in action. Hallowell some years ago traced the origins of Hitler to the philosophers of law who reduced law to the will of the state. In the United States, we have seen law steadily being replaced by regulations. Without agreeing with the validity of man-made laws, it must be recognized that all the enacted laws of legislative bodies are few when compared with the annual libraries of bureaucratic regulations, which are held to be binding by the courts. This drift from laws to regulations is a logical one in humanistic cultures. If the state is sovereign, the state does not need the ratification of its will by the people, nor by their representatives. As sovereign, it has a lawmaking power independent of the people, and it progressively asserts this power. The drift, then, into a totalitarian order can only be arrested and reversed by a return to the sovereignty of God. No laws passed to arrest that drift can succeed. No sovereign can be bound by the laws of a subject. Men cannot bind God by their laws and wills, and when a state is accepted by men as sovereign, it is freed from all human restraint. Only a return to the one true God and sovereign can reverse man's condition of bondage.